How important is it to consummate a marriage? When people marry, it's commonly assumed they will live together and engage in a physical relationship. But in New York, failing to consummate a marriage doesn't automatically mean the union can be annulled. This common misconception often leads to confusion about legal rights and marital status. Under New York law, consummation only becomes relevant if one spouse is physically incapable of sexual intercourse and that incapacity was unknown before the marriage. In such cases, annulment is a possibility, but it must be proven, and strict legal standards apply. New York law sets out 5 grounds for annulment. Only one of them relates directly to consummation: a spouse's incurable physical incapacity to engage in sexual intercourse. The spouse seeking annulment must not have known about the condition before marrying. And the action must be filed within 5 years of the wedding date. This isn't about emotional hesitation or mutual decisions, it's strictly about physical ability. The law clearly separates impotence and infertility. Only impotence, meaning the inability to perform sexual intercourse, is relevant for annulment. Infertility, or the inability to conceive a child, does not qualify. Courts focus on whether the physical act of consummation was possible, not the couple's ability to start a family. So how important is it to consummate a marriage? Legally, consummation is only critical in narrow cases involving annulment based on physical incapacity. If both spouses simply choose not to consummate the marriage, that's not a reason for annulment. But if one spouse is physically unable to engage in intercourse and the other was unaware, it could serve as grounds to void the marriage. To prove that a marriage has or hasn't been consummated, courts often rely on the spouse's sworn statements. Other types of evidence might include medical records or witness testimony, especially if there's a dispute. The burden of proof lies with the person requesting the annulment, so credible and reliable documentation is key. An annulment declares a marriage legally invalid from the start, unlike a divorce, which ends a valid marriage. Even if a marriage is annulled, issues like child custody, support, and property division can still arise. An annulled marriage does not erase responsibilities to children or eliminate financial obligations. Navigating this process without a lawyer is possible, but it's rarely advisable. A family law attorney can help ensure paperwork is correctly filed, legal standards are met, and timelines are followed. Because annulment cases often involve sensitive personal details and strict evidence requirements, having guidance from a law firm can make a meaningful difference. At the law office of Ryan Besinque, our attorneys understand how personal and emotional these matters can be. Whether you're exploring annulment, separation, or divorce, speaking with a knowledgeable lawyer can help you make informed decisions about your future. To learn more or schedule a consultation, contact the law office of Ryan Besinque at 929-251-4477 or visit us at 115 West 25th Street 4th floor, New York, 10001, United States.